All right, welcome back, committee. We're going to open public comment on the judiciary topics. Do we have anybody online for judiciary topics?
Yes, sir. We have two online. We have Andy Somerville from Landsat and Eileen Thornton.
All right, let's bring in Ms. Somerville.
Good afternoon, Mr. Chairman.
Yes, we can hear you. Please tell us what you want us to hear.
Great. Andy Somerville. I'm the Executive Director for the Wyoming Association of Mental Health and Substance Abuse Centers. And Mr. Chairman, I just wanted to maybe clarify and add a little bit of context to the conversation surrounding the diversion program and the provider involvement from that conversation. As was referenced during the presentation, behavioral health reform really plays a large part in this process. Non-state and state level criminal justice involved are a tier 1 priority population for the community mental health centers under that reform process. We have been putting in a number of pieces together over the last 2 years or so to try to dovetail with that behavioral health reform process so that this is as good as it can be starting July 1 of next year. One of those pertains to the workforce topic and the workforce discussion. While Wyoming is definitely in a mental health provider shortage, and it's pretty severe, one of the most severe that we've ever seen, we have made some strides in that area. I reviewed our current openings for mental health professionals up in both the county that was referenced for the pilot program. That county right now has 5 clinician openings in the community mental health system. So we definitely have a need there, but we're not concerned about being able to meet that need in that particular county right now in terms of workforce. We were able to work on a number of bills last session that helped us with that workforce challenge. That includes the licensed professional counselor compact, the psychological compact, and a few other things. The bill that passed last session for the defendant's mental illness exams, while not tangential to the diversion program, it's going to allow community mental health centers to perform those on an outpatient basis. Again, getting at that idea of trying to keep mental health clients out of jail or move them along as quickly as possible. I would imagine, in fact, I fully expect the providers up in that county for the pilot program to utilize telehealth services, as well as some regional-based community mental health connections and other providers up in that county to meet that need. We really do think that the diversion program is another important step, especially to try it as a pilot. What we know about mental health clients is that they are going to end up in the system one way or another eventually. The earlier that we can get them, the less costly it is and the better it is for them. And while it might be, having them stay in a crisis stabilization center for a couple of weeks to get them sorted out, it's certainly better than having them end up in the state hospital 6 months or 12 months later. I'd also just share with the committee, one of the things that WAMSAC hears, and I personally hear a lot from, is from the sheriffs about the mental health clients ending up in their facilities. And how do we get around that? How do we get these folks where they need to be? How do we get them services? This diversion program, as we've looked at it, we think it really dovetails very nicely into that conversation as another tool to be able to try to address that for the sheriffs. The last piece that I would just let the committee know is that, there has been some investment by the state, historic investment in infrastructure in terms of beds and availability by the State Land and Investment Board through the ARPA dollars. We have 3 separate community mental health centers that received funding to either renovate and improve, or in one case, build a new facility for crisis stabilization, which would be the most likely candidates for these types of clients that would be contacted through the diversion program. They would most likely need a crisis stabilization bed. While we always have concerns about bed numbers and availability in Wyoming, I guess the point is we are trying to make some strides forward to address some of those concerns. With that, Mr. Chairman, just WAMSAC supports the diversion program, and we hope that it goes forward. And we'd like to give it a try, and I'd be happy to answer any questions.
Thank you, Ms. Somerville. It's always very informative. Senator Landon.
Thank you. Ms. Somerville, thank you very much for your patience and coming back after lunch to visit with us. When you talk about crisis centers, are the community health centers really the only thing that we have? We struggle with the physical structure, do we not? And can you speak a little bit about our health centers and what kind of capacity we do have?
Ms. Somerville.
Mr. Chairman, Senator Landon, so community mental health centers provide a crisis stabilization. There's 4 of them across the state. They're in Worland, Sheridan, Rock Springs, and Cheyenne. That's kind of the bedrock for community stabilization. In Wyoming, those systems are regionalized, so they're not county specific. On top of that, there are a number of other types of providers in that continuum that can offer types of crisis service. I believe we've got 5 or 6 hospitals that have some type of psychiatric unit or psychiatric beds that are available. In terms of crisis, those are the 2 best places to put folks. I'm not aware of any other providers that would have a crisis type bed. But what I will tell you is that we are certainly having conversations about how to expand that in a way that allows for a bed or a facility. If I were in charge of everything, I would say I'd love to have 1 or 2 beds in every county where law enforcement or somebody could take somebody that was not the jail. That's idealistic probably, and maybe a future project. But the way the system works now, that regional aspect for Wyoming is incredibly important. I believe, as I'm counting, we have approximately 35 crisis stabilization beds in the community mental health system that are available. The system is designed to be an overflow system. So in one facility where there are technically 9 beds for crisis stabilization, generally on an average day, those are maybe half or 2/3 full. We always try to keep a couple of extra beds for moving clients around or if there's extraordinary circumstances. So we generally do have a little bit of capacity. It might just not be in the exact location that somebody needs it in. And so we work on moving those clients around the best we can.
Further questions? I don't see any. Thank you for joining us. And again, thank you for hanging over the lunch hour to join us this afternoon.
Absolutely. Thank you, Mr. Chairman.
Who's next online? Okay.
Good afternoon, Mr. Chairman. This is Eileen Flory. I think that I am next to speak.
Thank you. We can hear you fine. I appreciate you hanging over the lunch hour, and please share with us your thoughts.
Okay, so I would like to propose an amendment to the Wyoming State Statute 3-2-201 to grant permission for a guardian to seek a divorce on behalf of the ward. We recently submitted a question to the Wyoming Supreme Court to ask if my husband as guardian could ask for a divorce. We were denied that request, which causes several challenges. And I can state my reasons on why I think a divorce is necessary if you would like me to proceed.
Thank you. Is that all? Okay.
Yes. Sorry.
Very good.
My
So
husband.
can you
Go ahead.
tell us just a little bit about the background of what the case was about? We don't have unlimited amount of time, but just a kind of a synopsis of what the case was about and why the court ruled the way it did, if you know.
Well, we weren't really able to provide any evidence on the reason why we needed the divorce. We were only able to ask the question and to the Wyoming Supreme Court if we could proceed with the divorce. So we were able to provide all the evidence that we have against the defendant. My mother-in-law, who is Madonna Flory, she has Alzheimer's and dementia. She is unable to make decisions on her own behalf. So that's why it is necessary to get her divorced, because we're trying to move forward with trying to divide her assets, and we are unable to do that with her being continued to be married to the defendant. The defendant hasn't had any contact with his spouse for over 2 years, and she has not resided with her husband for 26 months. Therefore, we would like to resolve this and get divorced so we could split the assets, because eventually when we have to put her into a nursing home, we will need those funds to provide care for her.
Thank you. That was helpful. Do we have any questions? And I believe you've been in communication with Representative Rodriguez Williams, and she's provided us with a little background information as well.
Yes, Chairman.
Just so you know, the soonest the legislature will meet to even possibly contemplate this change in law will be next January.
Okay.
So just so you have an understanding, and
Okay.
normally if we make a change to law, it doesn't go into effect until July 1st of the following summer. So may not be immediate relief for you, even if we're able to get the statute changed.
And Mr. Chairman, I do understand that, and I respect the timeline. I just feel that there is a definite need for this to move forward, just because I feel that we're at a standstill with my mother-in-law being stuck married to her spouse. He travels the world constantly. He's always out of the country. He's spending their money, and there's just not a whole lot we can do. And we feel really helpless at this point that we cannot file divorce and split the assets. So we really appreciate you taking the time to move forward with that.
Thank you for joining us. We have a
welcome.
good question from Representative Jennings.
Thank you, Mr. Chairman. Sorry about your circumstance. I'm curious, is there not a way, I mean, if he hasn't been around for 26 months, isn't that like abandonment or something? I'm not a lawyer, but seems like there would be some relief available there.
As far
Ms.
as
Flores?
Sorry about that, Mr. Chairman. As far as filing abandonment, I would have to contact our attorney, who is Jennifer Jensen. I'm not sure how that works, to be honest, but he has abandoned her for 26 months. And like I said, he's out of the country constantly. So it's hard to even get a hold of him. And so it's a difficult situation to be in if we need his signature or his approval on anything. And although my husband has guardianship over Donna, there's certain things that cannot be done without the approval of the spouse.
Thank you. Representative Jennings, as I understand the issue in this case is the authority of a guardian is statutorily defined, and the Supreme Court rules that that definition did not include giving a guardian the authority to pursue divorce, and probably extends a situation like abandonment as well. But so interesting topic, and we'll try and see what the will of the committee is. But thank you for joining us.
Thank
Mr.
you
Chairman.
very much.
Oh, Senator Case, you have a question?
Oh, Mr. Chairman, I mean, this would be a generic piece of legislation which would have broad applicability, I assume, if it were written correctly, but the Constitution of the state of Wyoming actually has a prohibition on special interest legislation. And one of them is granting of divorces. And I know that's not what we're doing. We're giving her access to the courts, but I think that's kind of interesting twist to all this too.
Yeah, we'll certainly keep the constitutional limitations in mind. So. All right, thank you so much. Is there anyone in the room wishing to testify on public comment for judicial topics? Representative Pendergraft.
Thank you, Mr. Chairman. Committee, welcome to Sheridan. We like it here. I hope you do too. It was Jesus that said the meek will inherit the earth. That word meek is an interesting word, because when you get down to the bottom of it, what it means is power with restraint. And so what I'm here advocating for today I would say, is a judicious use of force. As the legislators, we have a big stick. And it is kind of a knee-jerk response of people whenever there's a societal ill to say, oh, there ought to be a law, the government must do something. And sometimes I think we all get a little bit mad with that power and are very quick to go out and create yet another law. I was speaking at an event here a few days ago, and I asked the crowd, I said, do you think that Wyoming has enough laws? Is there anybody here that thinks we need another law? Not a soul raised their hand in an audience of about 100, 150 people. Part of the basis for my feeling is that every time we cede responsibility, our personal responsibility, we cede a little bit of liberty with that. And so on the one hand, you have a situation that would be anarchy, and we don't want that. And on the other hand, you have a situation that would be tyranny, or we empower someone to become tyrannical, and we certainly don't want that. I'm an old soldier, Representative Waschitz's an old cop. Each of us have had a substantial amount of training, I would suspect, on the judicious use of force. And that's what I'm appealing for today. I guess I would sum it up and say, we've got a lot of laws that Representative Jennings brought up a couple of times. What about the laws that are already on the books when we were discussing the possibility of newer legislation? And I'm not saying that we don't ever need to make another law, but we really need to make sure that we're employing effectively the laws that are already on the books before we go and pile onto it. And it's also a very unique opportunity to get to speak to both legislators and adjudicators, because I speak to adjudicators, unless that law is enforced, it's meaningless. In fact, it's worse than meaningless, because what it does is devalue or inflate in some way the meaninglessness of law, the amount of disrespect for a law. So if you have a whole bunch of laws and nobody's really paying any attention to them, then you devalue the rule of law. And I would like us to try to work our way back to where we greatly value the rule of law. We don't have many laws, but the ones we do have, we enforce. And I'll illustrate this in closing. I like to fix things. I'm a mechanic, I'm a carpenter. I like to build things. I got a lot of power tools. Make Tim Taylor look like a piker. Okay. So I've been doing this for 35 or 40 years and accumulated all of these tools. And the company that I was a partner with until very recently, when I took on this responsibility, I could no longer give them the 40 hours a week. And so I sold my shares. And in so doing, I had to give up some of the other perks that I have. One of them was a big tool trailer. And they gave me a little one. And so I've got to go through all my tools and figure out, what do I really need? You know, I have 7 cordless circular saws. That's kind of dumb. But it is so easy when in the heat of the moment to go out and just say, oh, we need a new one, or I need one, so I'll just go get a new one. And we get one to do a particular task. Before we pass new laws, let's make sure that we're using the current laws to their full extent. With that, I'll close my remarks. And if anybody needs a circular saw, just ask. Thank you.
Any questions, sir? Representative Pendergraft? Representative Jennings?
Thank you, Mr. Chairman. Could we get prices on those?
You haul it, you can have it. Thank you, Mr. Chairman.
Thank you very much. Do you have anyone else in the room wishing to testify on judiciary topics? Anybody else on Zoom? With that, I'll close public comment. I would suggest that before we go to committee actions on judiciary topics, let's go ahead and hear the 2 corrections topics that we have on our agenda. The people that are associated with those topics can get on the road, and we'll take up all of our day 2 committee actions all at once. So Director Shannon.
Mr. Chairman, committee members, my name is Dan Shannon with the Wyoming Department of Corrections. Thank you for having me today. I want to start out by thanking you for considering these two very important topics as they relate to our agency. These topics are going to that I'm about to discuss are specific to staff safety, inmate safety, as well as operational efficiencies. I'm here to address the Wyoming statute 164203. It's the Public Records Act, which contains exceptions for grounds for denying the right of inspection to public records. Specifically, Wyoming statute 1604 states the custodian may deny the right of inspection on grounds that disclose and may be contrary to public interest. And I think the key word there is may. It's also always open to judicial review and things of that nature. The statute specifically references the records of investigation conducted by or the intelligence information or security procedure of any sheriff, county attorney, city attorney, attorney general, state auditor, police department, or any investigatory files compiled with any other law enforcement for prosecution purposes. I'm requesting for consideration that our department's investigative service unit only, not the Department of Corrections. This is a 7-member team. Is the investigative service unit only to be added to this list of identities. And I would explain why. I want to reemphasize that the purpose for this is intelligence information, security procedures, and prosecutions. I'm referring to the WDOC investigative service unit, which consists of 7 individuals. As I mentioned earlier, I'm not asking that any WDOC investigative records, departmental records, or documents to be considered. Rather, my request is for a very specific set of documents, the investigations. I'll explain the functions of our investigative unit a little further in my comments. The reason is that when ISU redacted records are released, usually we have to deny all or most of the safety records under the categories. There's typically enough unrelated information contained in the investigation to pose the safety risk. And on our next interim talk, you'll see that 70% of our individuals that are shipped out of state are as a direct result of these investigations being turned over to those confined. Even when we comply with the state's position of transparency through redaction, interferences can easily be drawn and cause safety concerns. Unlike many large correctional agencies, in our state, we have 5 correctional facilities and 23 parole offices. If you're a female, we have 1 facility. If you're a male inmate and you're not classified as a medium individual, we have Torrington or Rollins. That's it. By redacting information, inmates are left to fill in the blanks, which is a greater concern, as inmates can request these documents as a public request. The outcome of this action requires that we house inmates out of state. And I'll get into my second interim topic, and you'll see that over 70% of these individuals are a direct result of this. Or restrictive housing to their incarceration. And to me, that really does not serve the purpose of our mission. It is critical for the Department of Corrections to have some discretion when releasing information pertaining to investigative intelligence information and security procedures. The ISU investigative and intelligence files are not protected like the records of other law enforcement agencies under State Statute 116.403. Likely, this is a result of the law's enactment date being before the DOC's uniformed staff became peace officers in 2007. As the corrections is the 3rd largest agency, we employ a variety of staff, including post-certified staff and investigators. Given the size of our agency and the added challenges of our correctional agency faces in housing and managing state's adjudicated population, we conduct a wide range of investigative and intelligence efforts, both internally and externally. This unit's been in place for over 20 years and it's maintained the investigative body who are highly trained to investigate only serious issues, misconduct, major contraband, intelligence gathering, gang activity, and serious misconduct. All criminal activity investigations are submitted either to the prosecutors as well as to the post commission if it involves our staff. The investigative service unit is made up of highly respected post-certified investigative staff who report directly to my office, which is the best practice standard in corrections and allows them to work independently without influence. The agency counts on this unit to provide decision makers such as myself with impartial and uninfluenced opportunities to make well-informed decisions. Beyond with our agency, we also coordinate investigations and intelligence information with other law enforcement agencies, federated partners. We have a K-9 support unit within our prisons, probation and parole, contract agencies. The ISU is also the hub of the intelligence information and works hand in hand with other state agencies. And we're also tied in with our DCI state analyst team. We have employees right there. Often our ISU is requested to conduct outside agencies investigations. We've conducted investigations for A&I, the Liquor Division, the Public Defender's Office, Military Department, as well as other law enforcement agencies. This information becomes a part of the record, which is subject to release without statute. Some of our DOC records are protected in statutes such as 719-101 to 103. It protects criminal history records. Criminal history records information is limited to information that's recorded as a result of the initial criminal proceedings. It does not include intelligence data, analytical prosecutorial files, or investigative reports. Therefore, the DOC pre-sentence investigation reports may be released to criminal justice agencies unless released in a pre-sentence investigation report can compromise public safety. Wyoming Statute 71349 protects probation and parole records and states all information and data obtained in the discharge of official duties by these agents is privileged. So if our unit, our ISU unit's required to conduct an investigation that involves a probation or parole agent or thereby it's protected, but it's not if it's inside of the penitentiary. It's the same unit and their post officers. To me, this is interpretive that all case files from gathering this information for the PSIs to daily supervision, the ISU staff is required by policy to investigate serious matters. As I mentioned, it also relates into the institutions. Additionally, department finds discrepancies between investigations conducted at county jails versus our state prisons. For example, if an investigation takes place at the county jail, let's say in Carbon County, it's afforded protection under the law. However, the same type of incident can occur at our penitentiary investigated by peace officers, and it's not protected. With this heightened level of gang violence and intelligence system compared to county jails, it's quite surprising to me. I fully support transparency and understand the correctional systems are built on public trust. We must balance that trust to ensure we do not sacrifice the safety of the public, those we supervise, or our staff. In testifying before you today, I asked nothing more than the other peace officers. The DOC will continue to provide transparent information to the public. We have a large, and I'll get into it just briefly, we have a large amount of requests, emails, contracts, payments, anything. I'm not requesting that. I know in the past, it was after 2007 when the officers became post. At that time, the administration asked for the Department of Corrections to be exempted. And that's not what I'm asking. I'm asking only for investigative files from an investigative unit that involves potential criminal activity. And I'm asking that under the statute, it can be considered as the others that'll say may. As I said, it's open to judiciary review. When we do submit files to prosecutors, a lot of times because of that information, we ask for protective orders or in-camera reviews, things of that nature. Regardless, as I mentioned, the DOC, last year, we received approximately 295 public requests in 2022. This request required several thousands of documents. This isn't about the work. This isn't about slowing down the work, but the interim topic is it's about public safety. Of this request, 22% were from inmates requesting thousands of documents, including our investigations. So the option we have is to redact. We're open to ombudsman reviewing them. I'm fine with that. But it doesn't take much unless you redact almost most of the material because of the footprint of our institutions are so small. It doesn't take much to figure out on this date who came out and spoke to an investigator who was called out of a unit. These convicted felons are citizens, and I'm certain that they shall be treated as such. However, we need the tools in the daily struggle to ensure the individuals are not harmed when so many have this intent. Our current statute protects documents that put individual in prison, but does not protect the documents necessary to ensure their safe incarceration. Additionally, if a serious crime is committed in a DOC facility, the ISU will conduct the investigation. The law enforcement investigation of the same incident would be protected, but not the ISU. In conclusion, I'm asking for consideration to be the same qualifications. We can continue as we have been. And in my additional interim topic, I'll discuss about how we house inmates out of state and how that's taken place. As I mentioned, 70% of them are a direct result of these investigations. And to me, we can continue to go the way we're doing, and I'll certainly respect the decision by the policymakers, but to me, it's ineffective and it creates security risk. Mr. Chairman, with that information, I'll stand for questions.
Thank you, Director Shannon, Senator Case.
Thank you very much, Mr. Chairman. Director Shannon, can you help me with a hypothetical example and just take it all the way through how one of these investigations would jeopardize potentially the health and safety of an inmate and lead to him being he or her being transported out of state? I'm just an example. I sort of get what you're talking about, but I don't know how your place works, so I appreciate it.
Director Shannon.
Mr. Chairman, Senator Case, certainly. It could be what we automatically may think just an investigation of an incident, some type of assault or some type of narcotic trying to be smuggled into an institution. But it also can involve individuals that are specific to certain gangs. We call them security threat groups. They want to denounce. They want to come out. They're providing information. They're saying, I want out. I want these tattoos removed. I would do it. When that type of information comes out in an investigation, unless you take all of that out, that person's a marked individual. So the option to constitutionally, we have a responsibility to protect the folks. So keep them in restrictive housing is not the appropriate answer. We can't keep individuals locked up like that, and it serves no purpose. So then the only option is to keep them in restrictive housing and protected, or I would contact another state and say, this is my situation. I'm willing to transfer this individual and accept one person from you. And with that, and I'll get into the second topic, we're in the Western Compact. We got in 1959. So we can do that with the Western states. There's no cost except offsite medical. So that's one example. Another example is if an individual is going to get prosecuted and we turn that information over, obviously they're allowed to have that, for discovery and such. So we'll ask for in-camera review or we'll ask for a protection order. But also that information, when we may have a family member ask, how did you get this? And those folks are marked individuals. It could be someone that is transitioning. I can think of a lot of different incidents where people during an investigation may report things and say, so-and-so assaulted me, so this individual attacked me, and he attacked me what I believe for these reasons. And from that point, we have to keep those people in a tight custody area that maybe are medium custody, minimum custody, that don't belong in that area. So it'll provide them opportunities to live a somewhat productive life and become a better citizen that we're going to return. I hope that helped answer your question.
Follow.
Mr. Chairman, I still got to think about all these, but that was helpful. I appreciate it.
Thank you, sir.
Other questions? Co-chairman?
Mr. Chairman, thank you. Director, thank you. Appreciate your patience with us today.
Sure.
On the agenda. Going back a few years, I'm looking down at the longtime chairman of corporations who has championed a lot of the work to try to work on government transparency.
Mhm.
And we run into situations like this where we have to say, you know what? This is something we need to look at. So it's not just a cut and dried, everybody saying, let's just throw the doors open, throw the books open. And I appreciate you giving us this for our consideration. That really helped, you giving us a couple of situations that I really hadn't thought of. I've kind of been a champion of, let's let the sunshine in and let's be transparent. But there certainly are times when you can't do that. So appreciate it.
Director.
Mr. Chairman, Co-Chairman, thank you for those comments. I certainly as well, I think will not gain any public trust without being transparent. And we do have investigators inside each facility, and we have them going to our pro offices. Those aren't the investigations that I'm discussing. As I mentioned, emails, communicate, we have thousands of documents in the Department of Corrections. And it's an open book. It takes a little bit sometimes to gather that information, but that's what we do. But there are specific times, and I'm not asking for those to be excluded. I'm asking under the same series as the audit and investigations. And with gang intelligence, we have inside this ISU, our 187 people, they work full-time intelligence in gangs. And that information is not just tied in with Wyoming, and it's tied in with federal partners and DCI and such. So historically, I have two choices: either redact it, most of it, which I don't know the purpose, or isolate the individuals. And that's very effective, but whatever the policymakers decide, I'll strongly get behind.
Follow up.
So I guess, the question might be then, and I apologize for not getting to a question. It seems that maybe the concern some of us would have is do we run any danger of closed book creep? The temptation to just couch some things underneath certain ways that we can withhold information that frankly probably should be transparent. Do you have any worries about that, Director?
Mr. Chairman, Co-Chairman, I can only speak for myself, and I would certainly understand. As I said earlier, I believe it's always open for judicial review, but you could say, well, maybe I could slide these investigations under this ISU or have things funneled. The policies have remained the same for over 20 years. I have no desire to change them. I think the system was well set up by the former director. It has many checks and balances. And lastly, I would also like to comment, when the investigations do come out, we do a cover sheet with our findings. And that finding will include if staff did things inappropriately, but it just gives a summary. And I still continue I do that with the ISU. Instead of me saying, no, you're not having this report, I can hide behind this document. You get a summary of what was substantiated, what wasn't substantiated, as well as how we got there and how it affected. We may say Officer Smith did this. We don't talk about what corrective action that took place to correct this type of behavior or ensure this incident doesn't happen again. But we certainly, they have a clear understanding what our findings were. And that thereby protects our staff and our inmates, as well as the public.
Thank you, Director. Appreciate that.
Representative Jennings.
Thank you, Mr. Chairman. Director, a real quick question here. What happens to that I understand while an investigation is active, is there what happens to the end of that? When it comes to an end, you don't just give the information out then? Is there a time frame in there, or is it forever closed?
Yeah. Mr. Chairman, Representative Jennings, at the conclusion, we will not provide the information during an active investigation. If it's a serious investigation, otherwise I'll try to provide what I can during that period. But at the conclusion, I have two choices. I redact it, or we'll provide the summary of our findings, so people will know exactly what took place and what corrective actions we're taking. What I wouldn't do is provide the base file of the investigation, the actual statements by certain individuals, because that would get them harmed. So if the allegation was that there was a misconduct by a staff member towards, say, an individual, an inmate, I would provide a summary sheet saying yes or no, it was substantiated, and this is the action that was taken. I wouldn't say that inmate Smith witnessed Mr. Smith do this behavior, thereby jeopardizing inmate Smith. Because if I did that, those individuals would be harmed.
Director, is it your testimony that you've actually had to release some of this information under existing statute? And as a consequence of that information release, you've had to move inmates out of state. Is that an accurate statement?
Mr. Chairman, yes, even the redacted information. As I said, if we were in a department that had there's large facilities that you can move people to in larger agencies. We don't have that luxury here. So with that being said, to answer your question, 70%, I think we have 49 individuals out of state. 70% of those are a direct result of our investigations. I can redact, unless I redact everything, which I don't believe in. I'm the first one to say, why can't we? Let's look at it. But unless you redact everything, it doesn't take much, because to say Mr. Smith was investigated at this time, or take out the person's name and say that person went out of the unit, then families will call in and say, I'd like to see a portion of a video. Could you tell me what took place on April 21st at noon? So I have to, there's no reason to hold that up. So I'll turn over a document like that. Then I'll say, it doesn't take much to say Chairman Washett's the one that walked out the door and must have spoke to investigators. And then if I don't, his example is, if I didn't protect the chairman and you get assaulted, now there's other litigation and liability against our state. And also it's not fair to you either, because you're being an honest person the best you can. So that's the situation I'm in.
It certainly doesn't make sense to me that the exact same information, if done pursuant to law dealing with probation and parole,
right,
is protected. But if it deals with operations or individuals inside an institution, that is not protected. Or the same kind of investigation done in a county jail is protected, done in a state prison. It's not. Those are the kinds of inconsistencies in law that don't seem to make a lot of sense to me. Representative Rodriguez-Williams.
Thank you, Mr. Chairman. Director, so if you have an inmate that has a certain gang affiliation and you make that decision to transfer them out of state for their own protection, or you make a switch with that other penitentiary out of state, are they paroled back in the state of Wyoming when they're up for parole?
Director.
Mr. Chairman, Representative Rodriguez-Williams, they're returned back to our state and paroled. Mr. Chairman, if I may.
Director.
We can't force the inmate to go. The inmate has to agree to go as well. Now, the alternative is restrict, is an alternative housing to protect them. But I don't have the authority to say you shall go to, say, North Dakota. The inmate has to agree with it as well, because it'll affect his family, his visits, things of that nature, he or she.
Seeing no further questions, let's move on to Representative Prevention.
Thank you, Mr. Chairman. Director, just slightly different topic, but on the topic of public records. One issue that we've seen with some of our public records law is that personnel files for investigations of misconduct aren't released specifically to the certifying body, the Peace Officer Standards and Training. How does your agency handle requests to investigate correctional officers if they have been terminated and post is looking at certification issues? And I guess, and maybe you are familiar with that statute or in terms of whether you can or cannot release that information.
Director.
Mr. Chairman, Representative Provenza, I am familiar with that statute, and there is no restriction to the post commission is exactly that, a commissioning of the certifications, and not just terminations, but any form of all form of discipline I personally review and sign, and it's sent over to Director Walsh, and he has unlimited access to it. sometimes and I'll give you an example, sometimes the commission's even harsher than what I thought they should have been. They don't always, I have to respect whatever they decide. We've had individuals that maybe received a DUI, first time offense, and they'll suspend them and pull their commission. So they're no longer peace officers in our state. And I have to respect that, but they have unlimited access to our files. They can review our personnel files, and because that information of their past behaviors would be in that investigation. Our investigative service unit, those individuals, and I would just like to comment, anywhere where there's potential criminal activity, an act that allegedly could result in firing, it's turned over to our ISU. So that takes the home unit out of it. We have 2 polygraphers, we have K9 units. So it not often, but anecdotally, maybe 20 times a year, we're asked by other agencies to participate, to do polygraphs, things of that nature. And it's protected at that moment because they're peace officers. But since it comes back into the penitentiary or Torrington, it's unprotected. It's just a risk for everyone.
Okay, so no further questions on this topic. Let's move into the compact topic, please.
Mr. Chairman, this will be relatively brief, and it ties in with the subject I was just talking about. As I mentioned several times, 70% of our inmates that are housed out of state is a direct result of our intelligence received by our ISU. Thank you for supporting our interim topic request to release consideration, and this request involves the Interstate Corrections Compact. The purpose of this request is to codify language under the ICC Compact in a Wyoming statute 73-407. This will give the DOC more options for housing inmates in correctional facilities in other states if need be. Many states, I believe there's 29, will not complete agreements with our agency without the entry of the Interstate Corrections Compact specifically, and I'll get into a little detail what that's about. There are many reasons, which I will discuss in a minute, for housing these inmates out of state, and therefore interstate compacts are an important tool to our operation. You may already be familiar with interstate compact. It's called ICOTS. It's for adult offenders. It's for our probation and parole. This is a formal agreement between all states that seek to promote public safety by systematically interstate movement. And I'll give you a few examples with that. Currently, we have 425 individuals from out of state being supervised. So they came to Wyoming, committed an offense, was adjudicated, and asked to return to their home state and be supervised. They can be returned back to Wyoming for violations. We have 781 Wyoming offenders supervised in other states. So why would we do this? The example would be if a person would be in, say, going to the state of Montana hunting and committed a violation, a criminal violation. It's been a productive citizen, has been working. Do we return them back to Wyoming for supervision to keep them to be productive, or do we make them leave Wyoming and head to Montana for 2 years sentence? If a person would be, say, at Deadwood and have some type of drinking violation, have a DUI offense, maybe second offense, do we have them report to South Dakota, lose their employment, lose their residency, be productive citizens, or do we have that transfer back to our state? And it's an agreement that, the probation and parole offices come to terms, and there's a set of guidelines. So it has quite an impact. Now that's for our probation and parole. For prisons, we're in the Western Compact. And we've been there since 1959. We're one of 3 other states that are not in the National Compact. The vast majority of the states that are members of the larger Interstate Compact. And as a result, the Western States Compact, which includes 14 states, it's not as meaningful as it was in 1959. And I'll explain a little bit how we do business. But I also recall during this past legislative session that the word compact wasn't as received as well as maybe as receiving, or I made a little note to receive Christmas cards. So I do have a clear understanding coming here today to say, boy, do we want to get involved in a compact? And we don't have to, but we can continue to do business the way we're going. Several states, as I mentioned, 29 states will not accept a Wyoming inmate because we were not a part of this ICC. Other states that have entered into agreement through the years with Wyoming, but they stipulate compact requirements. It's the same, it's the exact same language. I view this, as well as our department, as a potential problematic. It is because the receiving state is essentially asking Wyoming to abide by the compact language for emergency situation that we don't have the authority. That authority lies with you all, with your body, with the legislative body. Department of Corrections doesn't have that. We do have contractual agreements with 29 states. 23 of these contracts specifically refer to ICC. 3 specifically refer to the Western Compacts. 21 states, as I said, will not enter into agreement with us, and 4 do not participate at all. And prior to this hearing, those 4 states are Massachusetts, Wyoming, Maryland, and South Dakota. I personally reached out to the folks, and they said they don't really know why. Massachusetts was the only state to say we kind of have limited. We just do it on the eastern side of our nation. We don't do it. No one really had an answer why. They said it's been that way for so long. We just write the language. I'm not comfortable with writing the language that I don't have the authority to do so. As I shared in my open remarks, the housing of these inmates, as well as housing inmates out of state, it's necessary for the safe operation for our correctional facilities. And I made myself some notes, safety concerns in notoriety. We've had inmates that have killed a correctional officer, assaultive behavior. We've housed them out. Known gang members who no longer can participate within our correctional facilities as a result of trying to get out or joining another gang, or also those who have been arrested as former correctional officers. We don't house. We've made compassionate transfers. The example that individuals is maybe from South Carolina who come here, they're doing quite a bit of sentence. Can we have them home closer to families? Is it more productive? It's at the cost of their family. There's no cost to the state of doing that. Another reason that I feel is the most important is with our medical contracts. We've had individuals that are quadriplegic that got assaulted. They're quadriplegic. We've had people that were not able to have medical care, or we transport sometimes even several times a week to Denver, and maybe a state like Iowa or Missouri has that type of facility at no cost to us, and we switch inmates out. It saves us a considerable sum of money. So these are things that we take in consideration when we do that. Currently, we have 40, Mr. Co-Chairman, I think you asked this question. We have 41 inmates that are currently housed out of state. 2 are females and 39 are males. As I mentioned earlier, 70% is a direct result of that information coming out of our ISU. We are currently housing 37 inmates from other states, 5 females and 32 males. The only expense that we have is offsite medical, and both sides have to agree, so there's no cost. At any time, we can ship the inmates back. I think they have 7 days to come get them, or we'd have to go back and get our inmates. It's very rare that we do that, but it does happen from time to time. There's no fiscal with this, or the language you utilized before. There's no dues, there's no fiscal cost, there's no fiscal note to this. So in summary, I'll stand for questions, Mr. Chairman and committee. We can continue to do business, but when we have opportunities, because I made the decision, I'm not going to write any more agreements. As I mentioned earlier, I'm not going to say yes. They'll say, well, you have to agree to the compact conditions. That's out of our wheelhouse. That's not what the Department of Corrections is for. So we have 29 saying no, and I imagine we would have a few more. We do it for the safety of housing our inmates, and we also do it when I made that decision is for the betterment of the state. So we can continue to do the way we're doing it or improve.
Director Shannon, so your ask is that we pass specific statute that authorizes Wyoming Department of Corrections to be a participant in the Interstate Corrections Compact? That what your ask is?
Mr. Chairman, yes, initially I asked LSO just to add ICC to it, but you have to have the exact same language as the Western states.
Representative Rodriguez Williams.
Thank you, Mr. Chairman. Director, talk to me a little bit about how ICC operates when you're doing a trade or placing somebody out of state, and the different levels of security with penitentiaries. So how does that work?
Mr. Chairman, Representative Rodriguez Williams. We don't always, well, most of the times we'll go back and forth 3-4 times. We don't always get the person that was singing too loud in church inside their penitentiary that they want to send to us. But they also have people that have committed crimes that are staff members, maybe a police officer that was arrested, things of that nature, and they want to be housed. They are classified when they come in or during the time that they're spent, and it really depends on the security level for the transports. So if it's a compassionate request, the family pays for it, and the receiving institution does not. So a lot of times we'll have to fly those individuals.
Other questions? Representative Oakley.
Thank you, Mr. Chairman. Director Shannon. I have just a couple questions, ideas. So you said you're not going to write anymore. So have we been doing transfers with these other states? And then, but you don't want to do that anymore. So that's, I guess, one question. And then also I'm interested in terms like, what are the negative effects, if any, that are included in these terms? Because we talked about ICOTS at the beginning. I'll tell you, I about fell out of my chair when I got a letter saying we were going to get a $20,000 fine in the state of Wyoming via my office because of not following the ICOTS term correctly. In fact, you mentioned a DUI, but those misdemeanors can't be transferred to a different state, and then we can't even actually have terms, which the judge and I learned together. And I know around the state, a lot of us figured out some of those ICOTS terms, which we were unaware of before, but with some hefty penalties if you didn't follow. Is there any such equivalent with this compact? And I'm just a little interested in how it works a little more.
Director Shannon, what's the consequence of not following the compact if we join?
Mr. Chairman, Representative Oakley, thank you for your question. At first, as I mentioned, there's 29 states that won't participate because we won't follow the ICC. And what my intent is, after I really dove into this, I'm not aware of any negative, but I'm not going to continue. The example is if it's excluding our 14 states, I went through that part of the question first. Let's say it's Missouri, Alabama, something like that would really benefit housing. I don't think it's correct. It's been going on for 20 years, maybe probably since 59, or since the department was created in 91, that we just wrote the agreement up under the exact same language. And I think I'm overstepping my bounds, so I'm not going to do that. I'm not going to participate in that anymore. I do sit on the board with ICOTS, and I thought I said, multiple offenses with DUIs, but I may have misspoken. I'm sorry for that. I'm not aware. There's no national, with the prisons, there's no national board. There's no identifier. I've been searching this for several weeks prior to this hearing to say, who can hold us accountable for this? Who can do that? And I'm not, and I hope I am answering your question, because I feel kind of naive about it. I wasn't able to locate anyone, but I do participate with Wyoming on ICOTS as far as probation and parole. And I am aware that they tried to hold that accountable.
Senator Furphy.
Thank you, Mr. Chairman. Let me ask about this. I'm not sure I fully understand, but if you're expanding the number of states under this new compact, and there are more hardened criminals from some of those other states, do you have the choice? You don't have to accept them, or are you forced as part of this compact to accept those hardened criminals? Thank you, Mr. Chairman.
Mr. Chairman, Senator Furphy, both departments, the receiving and the sending, as well as the inmates, have to agree. no one can be forced to go. So I don't have the authority to force. If we had an individual that for some reason we wouldn't be able to control, I have access to send them to another state or send them to the feds under a contract. But under the compact, we cannot be forced to accept anyone, as well as the inmate has to agree to it as well.
Further questions? Senator Cooper.
Thank you, Mr. Chairman. Director Shannon, correct me if I'm wrong, please, but am I seeing this as basically trying to bring your operation into the 21st century so we have a better ability to communicate with other states? Are we just trying to modernize things? Is that what we're doing?
Director.
Mr. Chairman, Senator Cooper, to me, it's providing the necessary options that are available. There's departments that are light years ahead with women healthcare, and things of that nature that we're not there yet. And if I have an opportunity to switch and help someone, I'm gonna do it. As I mentioned several times, through attrition, I'm not going to keep signing my name till after I learned that information. So the number's 29. It's going to get bigger if we don't do something.
Further questions? Seeing none, I open public comment on or are there anyone else wishing to testify on the corrections topic? Anybody on Zoom world? Anybody in the room? Closing public comment on the corrections topics. Thank you, Director. Appreciate your comments today. We're going to start with you want to do the corrections? Maybe. What's that? Let's start with corrections. Okay, we can start with the corrections topics and work backwards to the judiciary topics. Okay, committee, what's your pleasure? Mr. Co-Chairman.
Thank you, Mr. Chairman. Committee, I'm compelled to have these two requests drafted up. The Public Records Act language, I'd really like to look at that. The Interstate Compact, I think we should expect to have some debate and some conversation about that, but I think drafting that as well. So I would request those two things based on the director's presentation today.
Mr. Chairman.
Director, we've closed public comment, but I will allow you to ask or comment.
Mr. Chairman, I wasn't sure if I was to stay or go. I'll step out.
You're welcome to stay if you wish, but we're just working as a committee now.
Thank you.
Turning your microphone off for me, please. There we go.
Mr. Chairman.
Senator Case.
I agree with Chairman Landon's proposal, but with regards to the public records request, I would like that to be limited. I don't know what that means to be any investigation or what. So I'd like that we think about limited in the circumstances where it needs to be limited in terms of protection of health and safety, perhaps of inmates or others. It could be members of the public too, because these investigations could disclose something about somebody outside the system, I would reckon. So kind of in line with other things, but limited to a certain extent and not just all activities of this committee, this investigatory committee. And I'm not sure what that means, and there are probably different ways to do that, but we've got great staff. Maybe they could think about it a little bit.
Yeah, and I think once it's drafted, we'll have plenty of opportunity also to tweak and work those, right? And make sure we're comfortable with the language that's in or out. And so I think we want a fairly narrow bill draft pertaining to public records releases on cases that were investigated by the Department of Corrections, ISU.
And Mr. Chairman, I believe as part of your meeting materials, Director Shannon did provide a template of, I think, his vision for that. And it would simply be inserting in the records of investigations, discretionary exception, just a mention of that investigative unit.
But Mr. Chairman,
Case.
and Mr. Chairman and Brian, thank you. But I looked at that too, and it seems like anything they did would be exempt from public records requests. And I'm saying it needs to be narrower than that in my mind. If it, you know, would result in potential harm to anyone, for example, or, you know, however, I don't quite know how to do it, but just any activity of that unit. I'm not sure I like that either.
Senator Landon.
So, Mr. Chairman, thank you. And I'm walking right along with the senator from Fremont. I think we might consider developing a new subparagraph related specifically to the Department of Corrections, because it is a little bit different kind of situation. And going to what the senator was talking about, I think all of our work that we've done on transparency and public records, it makes me a little reluctant on some fronts. On this one, I'm compelled to do something, but I want to make sure, just like the senator, that we keep it restricted to various concerns. And I don't know if that makes sense, Brian, but I think we might consider, instead of this draft, we might pull corrections into its own paragraph and deal with it that way.
Representative Oakley.
Thank you, Mr. Chairman. For what it's worth, I support what the director has submitted. And I think it's very fitting because what we're talking about is investigations, and it's very, very standard for records under active investigation, which is specifically what this says, records of investigation. And then it's conducted by literally every other type of sheriff, county attorney, city attorney, attorney general, auditor, police department. I just don't see any difference. I think Director Shannon explained it very well. This happened after, so they weren't included. This is the exact same type of records. I don't see why we would do a different carve out. I think this solves the problem, and it is this investigatory record, which they're treated differently. People, you're prior to the right of of people going, well, I want to know. Well, it's an investigation. Which I think is kind of, again, standard practice. So for what that's worth, I support this simple fix, and I think it gets us there.
Representative Rodriguez-Williams.
Thank you, Mr. Chairman. I would agree with the Representative Oakley and would hate to see any investigation compromise. I agree with the model language and what she just stated.
Committee, maybe we could do it. Maybe we just have it done both ways. Have a carve out with a separate paragraph version and then one based on the director's recommendation. Then in our September meeting in Douglas, we can take a look at the two, and as a committee, we can give our preference to one or the other. Does that make sense? Yeah. Is that approach? Senator Schuler.
Thank you, Mr. Chairman. I would also reiterate with the last two speakers that I think that the key to this issue is where the custodian may deny the right of inspection, the custodian of those records. So if it's contrary to the public interest, they can say no. I think adding the language the way it is now, but I also understand that we may want to carve out as well. But I think the way it is now, I would be very comfortable with it. Thank you.
Wham, Mr. Chairman. Mr. Chairman, I'm not sure what these investigations, I can see if they're about criminal activity or the action, but I'm not sure what all these investigations are. They might be about policies, for all I know, policies that, maybe they shouldn't be protected, that we should know about the policies. So I want to wait and see. I'm still not totally clear on this.
Okay, so Brian, can we do two? Yeah. Take it both ways and we'll talk about it in Douglas. All right. Mr. Co-Chairman, do you have another request on corrections topics? Senator Case?
We agreed to do the compact one, right? We did.
Anything else on corrections? Representative Provenza.
Thank you, Mr. Chairman. I don't think bill draft request is necessary maybe at this point, but I will say on the topic of that Public Records Act, looking at personnel files, we know that Post has had to file in district court to get access to the records they need to do their certification investigations. I've had extensive conversations with Post, with LSO about these specific statutes. So there's plenty of research memo, I think, that we can pull from for that. I'd like to kind of have that conversation to ensure that the Records Act that we wrote doesn't accidentally exclude folks from being able to properly do their job at the AG's office.
Fair enough. All right, let's move back to the judiciary topics. Any actions from the committee on judiciary topics? Let's start with the public comment phase on the guardian divorce question. Representative Rodriguez-Williams.
Thank you, Mr. Chairman. I would like to propose a draft to amend statute 32201, giving potential authority to guardians to seek divorce on behalf of the ward.
Any other judiciary topics who want to have action taken on? Senator Cooper.
Thank you, Mr. Chairman. On the rural attorneys program, I think this is worthy of some further conversation. It's a great program in other states. And I'd like to see the draft put together based on the South Dakota program. Basically with whatever tweaks are necessary to make it our own. Then we can really consider how much further we want to take it.
Representative Oakley.
Short comment, but I was going to say pretty much exactly the same thing. Senator Cooper is one smart feller. But I just wanted to say I support that as well.
Mr. Co-Chairman.
Mr. Chairman, if we're finished with that consideration on the rural attorney program, and I too think it's appropriate we at least take a look at it. Whether or not the committee decides to forward to the session, we'll have to see. But Judge Fenn, I thought, provided us with some good information and some things that we really owe it to ourselves to consider. One is this consideration for threats made to judges and their families. I think that would be an easy fix in statute for us to 65305. I think I might not have written that down correctly, but I think that's an easy fix to some language to we just need work on that language.
So, Mr. Chairman, I thought Representative Oakley.
Senator Case.
Representative Oakley had a better suggestion in that area.
I
agree,
agree, and I would certainly defer to the representative. But we may want a separate statute. I'm looking at the representative on this, but you mentioned that was more jury tampering, and what I'm talking about is trying to protect our judges and staff. So,
Representative Oakley.
Thank you, Mr. Chairman. Yeah, I do think that. I think just making a very direct, exactly, statute, as I said, a statute on point that this is the prohibited conduct. And I was looking for my notes, but basically I just had written down threatening, intimidating, or harassing a judicial officer. I mean, as simple as that, something like that. Of course, again, Mr. Fuller probably has better wording, but just absolutely, very basically carving out and prohibiting that conduct, I think, is the easiest way to get there. So I would suggest that.
Representative Rodriguez-Williams.
Thank you, Mr. Chairman. Just to piggyback on Representative Oakley's comment, I'm just curious if there's need to more clearly define officer under 61104A. It looks like there's a note in here that it's with emphasis added that the statute does not define officer.
We could certainly do that as well. So what I'm hearing is a separate statute request that deals with the threatening of a judge or the judge's family members, and then a second request to maybe define the term officer in 65305. Representative Shestak.
Thank you, Mr. Chairman. And you actually said what I was going to add, and that is we need to, I do think the separate statute is appropriate. But I do think we need to add or judges' families. We have had examples of judges' families being harmed or killed by disgruntled members of the public. So I want to, I do want to push back a little bit on the idea of monkeying with the definition of officer, the comment I had for Judge Fenn. I think the more we specify it has a tendency to narrow the reach of that. And I'm kind of skeptical. I suppose we could look at a proposed definition, but I'm skeptical about changing that. I think that statute covers what it's supposed to cover. That covers it well, but it doesn't cover the situation where there's a direct threat to the judicial officer or their family. So I'm very much in favor of a separate statute that would cover that situation.
Mr. Chairman.
Brian.
Yes, the question I would have for defining officer in 65305 is the concept that we would define officer to just include judges and justices, or does the committee have some other definition in mind for that?
Representative Oakley.
Thank you, Mr. Chairman. Thank you, Mr. Fuller. I guess that my thought was to keep it narrow and to specifically either define it or just put it in the statute that we're talking circuit court. I mean, it's relatively limited in Wyoming, right? Circuit court judges, district court judges, and justices. I don't know. I mean, we could go ahead and there's municipal. I guess we could have discussion on that, whether, we want to include the conduct for.
Representative Oakley, just a quick question. I've often heard lawyers describe themselves as being officers of the court. Are prosecutors, defense attorneys, legal counsel, are they considered officers here? Do we just want to add the word judge so that officers, however broad, would still be included, and then add the word judge or justice in 65305, or are prosecutors and attorneys not considered officers of the court?
Thank you, Mr. Chairman. So attorneys are officers of the court, but and so in a way, I think what we need to make it clear and make a policy decision, because to be honest, I don't think we're looking at going that broad, because in essence, that would mean every attorney. Because using it in that way, officers of the court, but that's not really what we're looking at. And that's not how it's defined in statute either. So while you are an officer of the court, it's not, I don't think an officer for this legal definition, but also that's what we can do with this, right? Is define it. And I think if we are looking at the judiciary and not extending that to meaning any practicing attorney, then I think that's what we do, is say define judicial officer, and or just, or heaven forbid, just use the word we want, I guess, judges and justices. But my thought, even from a policy standpoint, would be that we are not broadening it to mean all officers of the court.
Representative Shestak.
Thank you, Mr. Chairman. I'm still very much in favor. Judge Fenn made a really good point in that 65330, the intimidation statute, I have the numbers mixed up, is designed for a specific purpose, and that is it's jury tampering. It's trying to influence the outcome of a particular proceeding that's while it's underway. That's what it's intended to do, and it does that fine. I don't think we need to mess with that. But what we're doing is we're adding coverage for things that are outside of influencing a particular, the retribution. It's not intimidation so much as retribution. Somebody comes after a judge after the fact for whatever reason, and we need protection for something beyond just the current proceeding. because these kinds of things happen outside of the courtroom. So that's a different situation we're dealing with. And that's why I think we want to keep the two separate. I would not change 305. I do think we need to add protection for judges and other judge-like people, municipal judges, whoever. I think judicial officers broadly at all levels need to be covered by the separate statute, and that's what I would look for in a new statute.
Okay, committee, I just suggested we can have these debates when we have the drafts in front of us. Let's just decide today what drafts we want LSO to put together for us, and we can argue about which we prefer, which language we need to tweak when we get together and Douglas. So Brian, do you have an idea of what we want on this topic, or do we need to clarify?
Mr. Chairman, I mean, there was a lot of discussion on that last concept. You know, for that 305 draft, I've heard two different concepts, and certainly would appreciate a little more direction in terms of if you want us to leave officer alone and just add judge and justice, or if you want us to define officer to mean judge or justice. You know, similar ideas, but different results, I think, in
Mr.
doing
Fuller, I think what we need are two drafts, one to create a whole new statute dealing with threatening judges and their families. And then we're going to have a draft that would amend 65305 to define officer or add judge justices to that statute. And then we can argue about if we want to actually move either of those forward. We get Douglas. Mr. Co-Chair.
Thank you, Mr. Chairman. A couple other things that came up under this safety and security topic. One, I was intrigued by some language that we read about in the materials. The state of Arizona, for example, I thought did a good job on a statute regarding personal privacy. Putting the judge, you remember the justice was talking about his home and other judges' homes being on the internet, for example, and keeping profiles off of websites. So I'd like to see something on that, Brian. And again, it was just personal preference, but I kind of liked what Arizona did on that, because what they did, they just basically said it's illegal to share private information of justices and judges. And so that would pertain all the way to the assessor's office and out onto the web. So, and then the second thing, Mr. Chairman, I might as well throw it out real quickly. The third and final thing that I thought we might want to look at, the justice indicated that we require in statute for the sheriff to frequent the courtrooms, but we don't specify that we expect them to provide security while they're there. So I wonder if that wouldn't be an easy fix with a little piece of legislation on that.
I would agree with that. I think that that's less than clear language that the sheriff shall attend to the court. What does that really mean? So, any other actions on the judiciary topics? Senator Schuler.
Thank you, Mr. Chairman. Again, the administrative office, the court staffing, I really, I think we need to offer some help there, but I don't know that we need it in the form of a bill draft. But I just started thinking about all the things you have to deal with, the increased IT issues and data collection and mental health and so on and so forth. So I don't know if we just need to keep that on the forefront and maybe make sure that they get the proper support when it comes time for budget requests and that sort of thing. But I think they made a compelling argument.
Mr. Co-Chairman.
So, Chairman, I appreciate the senator bringing that up. I also had that down as a note. And going back to yesterday, the Senator Case rightfully pointed out that sometimes the best way to go is to draft some legislation, and that can make its way through, and eventually, if it is introduced at some point, the Appropriations Committee would take it up. But I would say that a couple of positions in that administrative office structure to support everything from e-file and all contracts and data demands and vendors, and then a public relations officer being the second position. We maybe don't have to specify all that, but I say we draft a bill and try to we have that debate in our second meeting, but they certainly made a good case for needing a couple of positions.
Mr. Chairman.
Senator Cooper.
Thank you, Mr. Chairman. I'd like to kind of go along with what the co-chair here said, but I'd sure like Ms. Butler and her staff to bring the numbers to us of what she feels like she actually needs. We might think it's 2 or 3, but I'd sure like to go to the professional involved in this and really understand what her needs are.
Thank you, Senator. Committee, just
Work with her.
just my concern here about, I understand the idea of bringing forward a bill draft as a way to get the budgetary considerations before the Appropriations Committee. But we're going into a budget session where if we don't have 2/3 introduction, the bill dies. And the budget's going to be prepared long before that. So I'm thinking that the committee, if we really want some of these things, whether they're from yesterday's topics or today's topics that involve budgetary things, that we can put together a bill draft. But I also think we need a letter from the joint committee to the Appropriations Committee saying, these were the topics that we discussed during our interim. These are the ones that we feel were strongly justified, and we would encourage the appropriators to give some deference to those, because if the bills die on introduction, the appropriators are not going to see them, and then it's going to be left to trying to plug in budget amendments and so forth.
Mr. Chairman.
Senator Case.
Mr. Chairman, I don't entirely disagree, but the Appropriations Committee is they're the don't add any more committee. That's their job. The governor is the one that writes the budget, provides for the exception requests. And if we want to communicate to who does the budget, we should write a letter to the governor. And then he can add it in his budget as part of the request. It is true that a bill would require 2/3 for introduction, but it's also true that you can amend the budget with a majority vote. So, you know, that's your backup strategy if the committee wanted to try to manipulate some budget amendments.
Mr. Chairman.
Mr. Fuller.
Yeah, Mr. Chairman, if I may, just one clarification. I think certainly for executive branch agencies, you know, Senator Case's suggestion would be appropriate. The Supreme Court actually submits the budget
They do their own budget. That's right.
for the court. The Chief Justice is the one who provides that. JAC votes on the chief's requests and exceptions and all of that.
He's absolutely right.
So if the Chief Justice writes these things into her budget request, and the Appropriations Committee also has a letter from the Joint Judiciary Committee.
Bingo.
Then we're in business. On the executive branch, then perhaps we need to see what the governor's request is before the committee decides what to write. But I think a summary report to the governor about what we've learned this interim would probably be appropriate either way.
I see a lot of heads nodding in the back of the room. I think maybe we're on.
Yeah. Mr. Chairman, I think well stated. I certainly think good communication up the ladder from the joint committee would be appropriate in the fall. You know, I think for now we could, you know, either draft a bill or not draft a bill. I think the appropriate thing though is certainly to communicate. So, and you and I can plan to do that.
And Mr. Chairman, with that in mind, I would welcome, I guess, clear direction if the committee would like a bill draft for administrative office positions or not at this point.
I'm getting some heads shaking now, so let's not look at no bill draft with regard to judicial branch position changes. And the judicial branch did say they would bring to us some comments about whether or not there were statutory changes that might be needed for some of these innovations that they're looking at, and we can take those up in September. I would also ask, we had a couple of questions today with regards to why prosecutors are or are not utilizing particular statutes, and whether we might want to hear from some prosecutors aside from our own who might shed some light as to why some of these tools that are in the statutory toolbox are not utilized, and whether or not we really need to change statute. Mr. Co-Chair.
Mr. Chairman, just to throw out so we don't forget, really enjoyed the morning's conversation about the Navigator program and the idea to stand up a pilot up in Gillette. I think that certainly can be included in the communication that we talked about a few minutes ago. I don't believe that it requires any legislation, but how about if we stand ready? And I'm looking back at Ms. Butler. If it looks like there's a piece that we can help with as a joint committee, I'm sure you'll let us know. And in the meantime, let's not forget that Navigator program, which I think has really good promise. So.
Okay, anything else from judiciary topics? Committee work? All right. Mr. Fuller, you're on. Let's get a rundown of, and don't go too fast, but go through the list that you have of what you believe this committee has asked and thrown upon your table. I know we did too much.
Yeah, Mr. Chairman, I'll just run through, I guess what I would call are the clear actions for LSO in advance of the second meeting. I do have a separate list of requests that I believe the committee has made for other agencies and entities to present or bring to the committee at the second meeting in Casper. So just running. Mr. Chairman, I think the second meeting in September is in Casper, the third meeting, Douglas.
Okay. All right.
Yep. Okay, Mr. Chairman, first item would be a bill draft to adopt the uniform, this is my shorthand, Uniform Abduction Act for the abduction prevention orders. Second would be a bill draft for amending the statute on the custody interference. And as part of that, we will include in the bill draft, at least for the committee to look at, the affirmative defenses associated with that statute. Third would be a bill draft for amending the age at which educational neglect from age 7 to age 5. Next, there was a request for a memorandum on parental rights and offenses and the interplay between those items. Next was a request, and Mr. Chairman, I'm not sure if this would need to be prepared in advance. Certainly, I would follow your direction and the committee's direction, but a letter to the Joint Appropriations Committee on the Internet Crimes Against Children staffing and the Attorney General budget. I think really the substance of that letter would require, and I think this was one of the requests of the Attorney General and the Division of Criminal Investigation, to bring kind of what their staffing needs are, which would probably be a big part of that letter. Next was a request for research on the profession of forensic investigators, background, education, experience, things like that. Then a bill draft concerning the sexual exploitation statute, and also as part of that, looking at if the definition of certain material is sufficient to cover computer generated images or that animated images. There was a request for information regarding, I guess what I would call kind of the revenge. If we had, could do that, if our statutes contemplated that. A bill draft to amend 35-7-1031 concerning the substance type for the prohibition against controlled substances. A bill draft to basically schedule Delta 8. And my understanding of that was regardless of whether it was natural or synthetic in origin. Then a bill draft for the sex offender registration statutes to incorporate the 4 offenses that were presented by the Attorney General as registrable offenses. As part of that, we're going to look into the legislative history of that definition in 7-19-301 concerning, I guess, the offenses included that do not have some sort of sex-based element to that offense. A bill draft for a statewide medical examiner. A bill draft to provide reporting on cold cases and missing persons and the creation or the requirement for maintaining a database. A bill draft, I guess just what I took from this, kind of cold case options to include the ability to use retired peace officers to investigate these cold cases, as well as the provision of 2 full-time positions to the division for investigating cold cases primarily. Then a bill draft for the public records request.
Can we interrupt, Mr. Chairman?
Yes, Senator Case.
With respect to the cold cases, help me out. Didn't we have a discussion about maybe having other county officials or other officials be able to initiate the cold cases investigation? How did that come out? I remember, I'm sorry, and I don't remember fully.
Yep. Mr. Chairman, Senator Case, my understanding, the current state of the law, nothing prevents a local, meaning a county sheriff or municipal police department from investigating a cold case as it sees fit. I think the question was the division, criminal investigations role in cold cases. Should they have, some different role, expanded role, primary role? I'm not sure. I have to go back and look at my more comprehensive notes to see if that was included in a bill draft. I do have a note about DCI's duties. I think the tenor of that discussion was, could DCI accept, if requested, or should they be required if requested to investigate a cold case? I think that was my understanding of that discussion. Certainly a matter for the committee to decide, though.
And Mr. Chairman, I think my concern was it might not be someone in law enforcement. It might not be the sheriff, and that's where we had that crazy discussion yesterday too. Someone else could request of DCI and they would have authority to go forward, even if it was not the local law enforcement. It wasn't the sheriff or the local law enforcement.
And I think we had that discussion, Senator, that both the governor and the attorney general presently have authority to direct DCI to take over a case. Are you looking for someone beyond those two or the prosecutor?
Do they, Mr. Chairman?
Yes, presently the governor, the attorney general, or the prosecutor can make the request that DCI investigate a matter.
Okay, I think that's good, because if you were a local official and you wanted them to look into something, you could go through the governor. So thank you for that. I missed the turn yesterday. Thank you.
Okay. Yep. Mr. Chairman, resuming the list. So the 2 bill drafts concerning the Department of Corrections amending the records of investigation exception. One will be their provided language, which simply adds that investigative unit as part of that current exception. Another, a narrower specific exception for the Department of Corrections, but only if withholding disclosure is necessary to protect the health, welfare, or safety of another person. Then a bill draft for Wyoming to adopt the Interstate Corrections Compact. A bill draft to grant guardians the authority to seek a divorce on behalf of the ward. A bill draft to establish a rural attorney program in Wyoming. A bill draft to create the offense of threatening, harassing, or intimidating judges. And then a bill draft to define officer, or excuse me, to add judges and justices to 65305, the current intimidation statute. A bill draft concerning the personal privacy for judges based on an Arizona law. A bill draft to require sheriffs to provide security for judges and courts. And then, and again, Mr. Chairman, I don't know if this needs to be done. I'll follow your direction on a letter to JAC concerning the court's staffing needs.
Mr. Fuller, I think we can hold on those letters, budgetary letters, until after the second meeting. I think there's more discussion to be had before we spend staff time trying to develop those. Anybody, is that a complete list? Anybody find any deficiencies in that list?
We're gonna do 3 days next time.
That list is a little bit long, Mr. Chairman, but some of those I would suggest probably won't be committee bills.
I think the early discussion about this committee scaling back the number of bill drafts might need to be thought through again. But again, we can look at a bill draft. That doesn't necessarily mean that we're going to move forward with that as a committee bill for certain, whether it comes as individual legislation or not. So our next meeting is in September in Casper. And Senator Landon, did you have an announcement you wanted to talk about?
You know, I do. And Mr. Chairman, great job today. I appreciate committee, all your hard work. I've enjoyed these last 2 days catching up with everybody, and we're off to a good start. And Brian and crew, thanks to all of you for the help that you give us. I wanted the committee to join me in thanking Emily, because you know what? This is Emily's last meeting with us. She's going to law school. And I made her promise. Yeah. So the deal is, committee, go knock them dead, Emily, but also come back to us. You see, that's the deal that I made this morning with Emily. As soon as she gets that degree and becomes a lawyer, she's coming back to us. So anyway, thank you, Mr. Chairman. Good couple of days.
Maybe she'll come on this side of the table with us.
Yeah, maybe over here, you know.
Thank you, everyone. Boy, all the public comment and all the participation has just been superb. Everybody was right on point. And committee, thank you so very much for your preparation and due diligence through the meeting, and look forward to a wonderful summer, and we will see everybody together in September.